Welcome to Lexplainer, brought to you by Nomad Law. Today, we're going to be talking specifically about trademark registrations. And I want to look at both what a trademark registration does for you, but also what it doesn't do for you. Now, for purposes of this video, we're going to assume that you have a valid trademark. If you're confused about what a trademark is or whether your trademark is protectable, we go over some of that stuff in our other video called Can I Trademark That? And you should check it out. This video, I think, is going to be most useful for startups or entrepreneurs, anybody who's just starting out their business and is wondering whether a trademark registration is something that they need to worry about right off the bat. You know, how important is a trademark registration? Is it really worth the investment when there are so many other things competing for that initial capital? So let me tackle one of the easiest questions first, and that's, do you have to register your trademark? And this is a source of some confusion, I think, because trademark registrations sometimes show up on new business checklists. You gotta get a tax ID number. You gotta open up a bank account. You gotta register your trademark. And so that creates the mistaken impression that registering your trademark is a regulatory thing. Asking the government for approval to use your trademark. And that's completely wrong, right? A trademark registration in no way represents permission from any regulatory body to use your trademark. So if what you mean by, do I need to register my trademark is it a requirement? Well, that's an easy no. And this might also be a good opportunity to disentangle your trademarks from the name of your corporation or even the name of your business. The way I like to think of it is that your corporate name or your business name, that's about the relationship between your business and the government. Whereas your trademark, that's about the relationship between your business and your customers, right? A corporation is a legal person, and a person needs a name to identify it. And when you file a license for a fictitious business name or a DBA, that's you telling the public who it is that runs this business. So if you do something wrong, they know who to go after. Trademarks are different. Trademarks don't necessarily identify a business entity. Instead, they identify goods and services provided by that entity. A business might have multiple trademarks, and they may or may not have anything to do with the business name. And that's an important distinction because many times business owners will use their corporate registration or their fictitious business name filing as kind of a substitute for trademark registration. And then they're surprised later on when it turns out that there's a conflict between their trademark and somebody else's. They think, well, why did the Secretary of State let me file this as my corporate name if it conflicts with somebody else's? But there's two problems with that. First, again, the name of your business and your trademarks are two different things. And just because nobody else has registered this name as the name of their corporation doesn't mean that nobody else is using it as a trademark. Second, yes, a government office won't usually let you register a name as the name of your corporation if somebody else already has that exact same name. Just like they won't assign two identical license plates. It would get confusing. But government offices that approve business names aren't testing for trademark infringement. Trademark infringement, and I can't stress this enough, does not require that two marks be exactly identical. It only requires that they be confusingly similar. And when you register your corporation with the Secretary of State, they're not looking for that. But that brings up another important thing that having a registration does not do for you. And that's act as a shield against accusations of trademark infringement. Unfortunately, a registration just isn't a stamp of approval guaranteeing that nobody's going to sue you. If you're concerned about being sued for trademark infringement, A much more important step would be to have an attorney analyze your trademark and do a search, preferably before you start to use it. Even that's not a guarantee, of course, but it can help you at least understand the risks. So at this point, a lot of people might be thinking, well, if a trademark registration doesn't even keep you from getting sued for trademark infringement, why bother? Well, a federal registration has a number of benefits, and I won't get into all of them. Many of them are very wonky and legalistic, but here are some of the most important ones. First of all, it takes what is a very nebulous business asset, and that's the goodwill associated with your products, and it distills it into a particular property right that has metes and bounds. It provides a record of ownership and makes it easier to license the trademark or to transfer it if a business is sold or dissolved. Another big thing is that a federal registration is very helpful if you need to enforce your trademark. Again, I don't want to get too far into the weeds here, but just know that there are a number of important advantages in litigation to having a registration. It just opens up a lot more options for you. It also, frankly, just looks more impressive on a cease and desist letter to be able to say, hey, not only do I have a trademark, there's even a number attached to it. But I have a lot of clients who tell me, I'm never going to enforce my trademark. I don't care who else infringes it. I just don't want to get sued myself. Well, fair enough. But even if that's true, you still might want to consider a trademark registration. One of the most important benefits of registering your trademark is national priority. The way trademark priority works in the United States is that usually whoever uses a mark first has superior rights to it. Now, if you don't register your trademark, you still might have trademark rights. They're called common law rights. But they're limited to how and where you've actually used the mark in commerce. So in fact, somebody can come along later on, use an identical or very similar mark to yours, and they could come along and register it. And they might not be able to stop you from using the mark how you've been using it because of your common law rights, but they can box you in. This happens all the time. There's a Burger King in Mattoon, Illinois, that is not affiliated with the international chain. They were there first, but the other Burger King boxed them in, and now they can't expand anywhere else. A more recent case was with the trademark Islander IPA for beer. One brewery was using the trademark in the Pacific Northwest, but then another company came along and registered the trademark. Now there's two Islander IPAs, but the brewery that was using it first can only use it up in its own little small geographic area, and the second company gets to use it everywhere else. So even though I like to say that a trademark registration is more valuable as a sword than as a shield, it is very important defensively in that respect, that it prevents others from developing superior rights to yours. So to sum up, is it required or necessary to get a trademark registration? No. But is it worth it usually, considering the costs and the benefits? I tend to say yes. For more information, check out our website or our blog, or follow us on Twitter or Facebook, and so on. Thanks for tuning in, everyone.